All right, ladies and gentlemen, it is two minutes past the hour. We'll go ahead and get started. Wanted to thank everyone on this webinar for taking time out of their busy schedules to join us for estate planning strategies for rental property owners. We have a jam-packed webinar here with you with several special guests that will also be presenting on today's webinar. Before we get started, I'd like to do a few introductions. My name is Amit Urban. I specialize in 1031 exchanges and have advised clients on solutions and strategies to optimize their real estate holdings that meet their goals. Since 2017, I've advised on over $50 million in closed real estate. That includes securitized real estate, such as DSTs, and traditional real estate. I'm a licensed real estate broker in the state of California, and I hold my Series 22 and 63 securities licenses. What's not written on this page right here is that I grew up in a family of real estate professionals, and early on, I saw how smart investing and smart planning helped individuals build wealth. And now that I'm a real estate professional for over 10 years, I work with investors and rental property owners to help them with strategies to maximize their income potential, guide them through the regulatory process, and build them replacement properties, portfolios that meet their investment and lifestyle goals. On today's call, one of our guest speakers is Barry Finkelstein. From the law offices of Barry Finkelstein, who's an estate planning attorney. Thank you for joining us, Barry. Would you like to say a few words about yourself, Barry?
Thank you, Amit. I'm very glad to be here today. I'm going to give a high-level overview of estate planning and focus specifically on how rental properties fit into a well-structured estate plan.
Great. Thank you, Barry. Also on today's call is John Bacigalupi from Cantor Fitzgerald, one of the leading DST sponsors in the DST space. Thank you for joining us today, John. Would you like to say a few words about yourself?
Yeah, thank you for joining us. I think we're in a crazy world right now, and so we thank people for joining us today. And I think as we kind of talk, and Barry talks about the estate planning, and I can talk more about the Delaware Statutory Trust, I think it's going to be very important for clients to understand it and also understand why it's so popular right now, that fulfilling your 1031 obligations in a passive manner, not being a landlord, seems very attractive right now as we kind of shelter in place at home. So very excited to be here.
Great, thank you very much, John. So today's agenda, today's webinar is going to take about an hour, depending on how many questions come in. But at the end of the day, all three of us are here for you. We do this day in and day out. So if you have any question, please feel free to put it in the Q&A box or in the chat box, and we'll address it as we go through the webinar. I'll be monitoring both the chat box and the Q&A, and we'll be answering those questions as they come in. Today, we're going to go over introductions. We've done most of them already. We're going to talk about a concept in the Bay Area called trapped equity, which is very prevalent that many rental property owners are experiencing in today's market. Then we're going to hand it over to Barry. He's going to be talking about estate planning strategies specifically for property owners. And then John's going to jump in and talk about 1031 exchange basics, what is a Delaware statutory trust, and how it may potentially fit into an estate, into your estate plan. Then we'll wrap up with some Q&A and go from there. We understand that everyone has different background and different experiences, and not all the stuff we're going to talk about here today will be suitable for you, but we hope you walk away with two takeaways. The first one is you'll learn about new investment options. In today's webinar, will be the Delaware Statutory Trust. And the second strategy is on how to increase your passive income potential and preserve your wealth by preparing estate plans as well as utilizing 1031 exchanges for your rental property portfolio. Before we get started, a few disclosures. There's a lot on this screen here, but there are three main takeaways to take from this slide. One is that we're going to be talking about real estate and real estate investing. And whenever we're talking about investing, there's always risk associated with that. there are never ever any guarantees. So if anyone guarantees you a certain return or a certain outcome from an investment, turn around and walk the other way. And when it comes to investing, there are never guarantees. The second issue is we're going to be talking about tax issues, particularly regarding the 1031 exchange. Although the presenters on this call are well versed in this space, we are not tax professionals. So before making any move or making any decisions, please consult your tax advisor or your CPA. And the third thing is we're going to be talking about the Delaware Statutory Trust, which is available to accredited investors. Accredited investor is someone who has a net worth of $1 million, excluding their primary residence, or an income of $200,000 a year or more for an individual, or $300,000 a year or more for a couple. So that's many people here in the Bay Area who own rental properties meet this criteria. All right, a little bit before Get 1031 Properties, before we get started, we are a national real estate investment firm for 1031 exchange properties. We specialize in building portfolios that meet our investors' investment goals and criteria. Since 2017, my partners and I have done over 100 million in real estate transactions, both on the securitized DST side and on traditional real estate. We're dual license, which allows us to provide some creative solutions for 1031 exchange replacement properties. And we're affiliated with KW Commercial, which is a national brokerage firm with offices across the country, which allows us to transact properties in different states. And we're based here in Silicon Valley. So before we get started, let's get started. So let's talk about trapped equity, which is a very prevalent problem that many landlords are facing here in the Bay Area. What trapped equity is essentially is if you take the income that the property is producing and divide it by the value of the property, you're getting a very low return. You have all this equity that is not generating additional income for the rental property owners. In this hypothetical example that we see here, the net income is $30,000 on a $1.5 million property. You're getting about a 2% return on the property. Depending on your investment criteria, many investors would consider this a very, very low return on equity. Let's take another look and see a more realistic example. This is actually similar to a client that we worked with early or late last year. This is a client named Charlie. He sold a single family home in Santa Clara. Charlie purchased the rental property back in 1995. He paid $400,000 for the property, which included a loan. Currently, the property is netting $36,400 in annual cash flow. So if you look at the example here, the monthly income is $3,800 per month, and after expenses, including tax, insurance, maintenance, and reserves, the net operating income, what's left after expenses, is about $3,033, which annualized comes out to $36,400. This comes out to 2.28%. So even though he's generating a nice income, if you're looking for significantly more income, what options we're going to go through? We're going to walk through the webinar. We'll be talking about the strategies Charlie's used to defer his taxes and increase his income. So the next few slides, we're going to paint a picture of the current environment that landlords are facing and what Charlie was facing that helped him guide his decisions. As we look at some data that market data, we're seeing that rents are not keeping up with property values. According to Zillow, since 2010, houses have appreciated almost double the rate rents have increased. Furthermore, if you look at the chart on the right, CoStar's forecasted that rent growth will increase by 2% over the next few years. So if you're a rental property looking for significantly more income, you're not going to see that big bump in rental increase that you would like in order to maintain a certain level of lifestyle. Let's double click further into what we're seeing in rents from rent projections provided by CoStar. Since COVID-19, there are many challenges that are presenting, especially when it comes to rental growth rates. Bay Area asking rents are estimated to drop by 12% in San Francisco by the end of the quarter. In San Jose, it's going to drop by 11%. In the East Bay, we're seeing negative 6% in asking rents. And on the national level, we're seeing a negative 3%. So, so on top of asking rates dropping, we're seeing vacancy rates also expected to increase over the next few years. So like I said before, for rental property owners who are looking for that additional income, there are many challenges that they are facing from the market perspective. Eventually, we're also going to talk about what we're seeing on the regulatory front, but from the market itself, the rental increase is not going to be able to see any significant growth over the next few years. In addition to rents flattening or decreasing, many landlords are dealing with tenants, trash, and toilets, as well as roofs. As roof, it's owners that are looking for more passive type of income. There will be some challenges there, and rent control has also become an issue. And if you were to sell, there's a big tax consequence because of the capital gains. So there are many challenges that landlords are facing in today's current environment. Before I hand over the microphone to Barry, I just want to touch on a few issues of the regulatory environment here in California. As you guys know, back in November of last year, AB 1482 was passed, which limits rent increases to 5% plus inflation. And this applies to 2 units, so duplexes and up, that are 15 years and older. So rent control is in the state of California now, and this, even though it's not a significant pressure, there's a lot of momentum for more regulation. On the ballot this November is the Rental Affordability Act. This is also known as Prop 21. I don't know if you guys remember Prop 10 last year, which was repeal of the Costa-Hawkins. Well, ladies and gentlemen, it's back, and it's named the Rental Affordability Act. They pretty much just changed the name. And if they're successful in repealing the Costa-Hawkins this year, that will allow rent control for single-family homes, which was previously did not fall under rent control, and vacancy controls. Vacancy control is typically when a unit or a property in a rent-controlled market becomes vacant. Typically, the landlord is able to raise the rent to market. What vacancy control does is prevent the landlord from increasing the rent of that vacant unit to market rent. Instead, they're able to increase it typically 15% or any percentage from the previous rent. So it really limits how much the landlord can increase the rents once the unit is vacated. Additionally, on November's ballot 2020 is the split roll, Prop 15. A yes vote on this constitutional amendment would essentially require commercial and industrial properties to be reassessed at the market rate, essentially getting rid of Prop 13 for those type of properties. So if you're a landlord that has these type of properties and this gets passed, down the road, the property will be assessed at the market rate, which will obviously have significant impact on cash flows, will have impact on tenants, especially if the leases are structured as a triple net, where the tenant is responsible for majority of the expenses, and obviously will impact the desirability of some of these properties. So that's what's on the ballot for this November. So please be sure to go out and vote. Another thing I want to touch about is the COVID-19 response in California. This is a very, very difficult time for many people, but there's also just a lot of uncertainty around when rental property owners will be able to start collecting some of their rents, which makes it very difficult, especially for mom and pop owners that are relying on the income especially to pay off some of the debt service or other expenses as well. Each city and county has a different regulation, so please consult your website, your local jurisdiction's website. But for example, Alameda County, the moratorium for evictions would be lifted 30 days after the local health emergency is over. In San Jose, San Mateo County, and other cities, there's rent increases, late fees, or fines are not allowed in this environment. So given the uncertainty, it's a very challenging time for rental property owners and especially those that are looking for income as they plan for retirement. So now I'm going to go ahead and transfer the mic to Barry, who's going to talk a little bit more to us about estate planning strategies. Let me go ahead and change it here, and I'll go answer some of the questions that came in. All right, Barry, I've handed the host controls to you, and I'll stop my share.
Okay. Not going, there we go. Great. Welcome. This is going to be a high-level view of estate planning with a focus on how to deal with rental properties inside your trust or otherwise. So let me just go ahead and get started. Again, what this talk about really is you and your stuff. What happens to you and your stuff if you become incapacitated and after you die? Because at the end of the day, that's all estate planning talks about. I have two objectives for my talk this afternoon. One is that you walk out of here going, wow, if something happened to us today, we're fine. We understand who's going to step up, what their instructions are, and how everything's going to work. We're just fine. The other objective is you walk out of here and go, wow, if something happened to us today, we're screwed. So if that's what happened, then please talk to your attorney, talk to me, talk to somebody, because everybody is going to need their planning at some point. And like homeowners insurance or auto insurance, if you wait till after something's happened, it's too late. So this is one of those areas where you really need to be proactive. I have a disclaimer. Sugarcoating is for kids cereal. I don't sugarcoat. I have a dark sense of humor. So if I offend anybody or I shock anybody, I apologize. And if you're not offended or you're not shocked, you're not paying attention. So, as I said, everybody is going to die. And some of us are going to become incapacitated before we die. So if you go crazy and after you die, the question is, what happens? What happens to you? What happens to your family, your money, your property, your stuff? The answer to that question depends. It depends upon what, how, and who. What happened? Did you die? Or did you become incapacitated before you died? Dying is not the problem. Incapacity is the problem. So we're going to look at dying first, and then we'll get to incapacity in a moment. So how did you die? And by that, I don't mean car crash, heart attack, or whatever. Did you have your estate planning in place? Did you have a trust and a power of attorney and an advance directive? Did you have just a will? Or did you have this blank piece of paper that you meant to get around to, but you never quite filled it out? So we'll start with the blank piece of paper first. If you died without anything, you don't have a will, you're said to have died intestate, and that is without a testamentary device. If you died intestate, then by the laws of the state of California, everything goes to your spouse or to your spouse and children. Or if you don't have a spouse, then everything goes straight to your children. Or if you don't have a spouse or children, it goes first to your parents, then to your siblings, then to your grandparents, then to your aunts and uncles and nieces and nephews. Everybody gets everything when they turn 18. So if you're a husband and wife and you've got young kids and you don't have any estate planning and you die, get it when they turn 18. But before they do that, they have to go to court. And that's a whole nother problem I'm going to talk about in a moment. But say you go, hey, wait a minute, we've got a will. We're doing good. We've got a will. Well, it's better than nothing, but you can do better than that. Because again, wills have to go to court. We have to go to probate court. And in court, it's expensive, it's public, and it is time consuming here in California. Every state is different, but in California, probate is just bad. What an attorney can charge the estate is based upon the size of the estate. And when we're talking about real estate, we're talking about fair market value, not equity. When we're talking about stocks and bonds and investment accounts, it's the net value of the account. But we're talking about real estate. If we have $1 million property with an $800,000 mortgage, as far as probate is concerned, it's $1 million property. And I get to take 4% of the first 100,000, plus 3% of the next 100,000, plus 2% of every 100 after that, up to $1 million. So for $1 million property, the attorney fee alone is $23,000. And if your executor gets paid, they get another $23,000. So probate in California is very expensive. It's public. If anybody has probate, anybody else, whether they're related or not, can go into court, get a copy of that file, and find out how much they had and who they left it to. So Marlon Brando, Sonny Bono, Michael Jackson, Prince, they all had wills. Their estates ended up in the public spotlight because they ended up in probate court. And then it's time consuming. A good probate takes about 7 to 8 months. A bad probate can take over a year or more. So again, these are just some of the considerations of if you just have a will. Now, what happens if you become incapacitated before you die? Wills have no provision for incapacity. They only take effect on death. So if you just have a will and nothing else, and you become incapacitated, it's much more difficult for your loved ones to step in and take care of you. Zsa Zsa Gabor, Casey Kasem, perfect examples. They didn't have any estate planning. Their loved ones, their family, had to get a conservatorship. They had to go to court and get appointed in order to take care of these people's assets. Again, conservatorship is a court proceeding. It's public, it's expensive, and it's time consuming. And you never know who's going to show up. And it could be your evil twin brother who walks into court and goes, "Your Honor, I know they would want me to take care of them." Or worse, it's someone you've never met. So you wake up 6 months later, where'd your house go? Where'd your assets go? Who are these people that are running your life? You have no idea. Because you weren't proactive, this is going to get thrust upon you. But say you go, great, I've got a living trust. I've done my estate planning. Then you're a couple steps ahead of most people. Your estate plan is not just one document, it's actually 4 documents. It's your trust, your power of attorney, your advance directive, and your HIPAA. So what is a trust? In the simplest terms, a trust is a bucket. It's a bucket that holds title. It holds title to your house, to your investments, to your money, and your property. While you are alive and well, you're in control. The trust maker, the trustor, the grantor, the settlor, it's all the same term. That's the person who has set up the trust, and they're managing their own property and their money. But because it's in the trust and not in their name alone, if they become incapacitated, their successor trustees take over. And then after they die, the money either stays in trust or it is distributed outright for the benefit of children, friends, family, or charity. Now let's talk about rental property. Rental properties are a very unique asset. You can put your rental properties in your living trust, and I'm sure a lot of you who have rental properties have. The problem is rental properties are legal, target-rich environments. If you haven't experienced this already, I hope you never do. But they have a lot of equity typically, as Amit was talking about. So they make them very rich for litigation. One of the ways we shelter that litigation is by putting the rental properties into an LLC. And from my diagram, an LLC is like a little castle. And one of the attributes of castles is not only does it keep things from getting in, it also keeps things from getting out. So that if you have assets inside an LLC and, God forbid, one of them burns down and people die, the plaintiffs in that case, the people that are going to sue you, first they have to sue you, they have to win, they have to exceed the insurance policy. But if they exceed the insurance policy, if it's an asset in an LLC, their recovery is limited to the assets of the LLC. So if you have two properties inside one LLC and you get sued, their only recovery are the assets in the LLC. That's why some property owners will put each individual rental property into its own LLC. That way the liability is only that asset inside the LLC. Because the problem is, if you put your rental property into your trust, into the bucket, and something happens, and the claim exceeds the liability insurance, then all the other assets that you own are subject to the claims of your creditors, your cash, your investments, even your personal property. So there's a couple options for dealing with rental properties. Again, you can put them in an LLC, and you can put the LLC in the trust. That way, if you become incapacitated and after you die, your successor trustees can manage that asset. Now, LLCs are great, but they do have a couple drawbacks. If you have a mortgage on your rental property, mortgages on LLCs are very expensive because lenders know that they are one step away from you. So if you don't want to put mortgage up property, you can put it in the LLC as your personal property. Put a big liability policy on it. Insure it so that you have enough coverage that should something happen, your other assets aren't at risk. And then on top of that, get an umbrella policy. Get excess insurance. Nobody's ever going to complain about having too much insurance. They're going to complain about not having enough. Either way, you have to do something to protect your assets. Another thing to think about is title. Everybody has assets, everybody has real estate, but how they hold title to real estate here in California is very important. Do you have it as husband and wife, joint tenants, community property, or is it in the name of your trust? Each of these versions of title has different conditions and processes that happen when you die, so it's really important that you understand how your assets are titled. Moving on, power of attorney. Your trust deals with assets, it deals with money, and it deals with real estate. Your power of attorney deals with rights. If you become incapacitated, somebody needs to be able to file an insurance claim or a lawsuit or get money from your 401k or deal with your other stuff. That's the agent on your power of attorney. So your trustee deals with the assets of your trust. The power of attorney deals with all the other financial aspects of your life while you're incapacitated. Your advanced healthcare directive, also called a medical power of attorney. That's going to decide who gets to talk to doctors and make your medical decisions, or actually enforce the medical decisions you already made. When are they going to pull the plug? You want to get buried? You want to be cremated? Do you want to be an organ donor? What type of memorial do you want? All of these very personal and very important instructions are contained in the advance directive. So you don't want to leave these decisions to somebody after you're gone. You want to put them down in black and white so that the people who are going to take care of you know what it is you want them to do. HIPAA. HIPAA is the authorization to release information. It allows your friends and family to talk to the doctors, talk to the nurses, find out how you're doing, or to call up the insurance company, to talk to people in another state and find out, hey, you know, my dad just got sick. Is this claim covered? I'm on his HIPAA. You can talk to me. Now the question becomes who? Forgive my puns, but I like puns. If you become incapacitated and after you die, who are these people that are going to step up and take care of everything? In whose hands are you leaving that responsibility? When you think about your trustee, think about your agent, think about your checkbook. Who are you giving your checkbook to? And before you give them your checkbook, how do they deal with their own checkbook? It's a very important consideration. Everybody, you, me, Bill Gates, we all have the same choices when it comes to who's going to be our trustee. It can be friends and family, it can be corporate trustees, or it can be private fiduciaries. Friends and family work great for small estates, where it's very simple, where everybody gets along, nothing's too complicated. But remember, emotions around money tend to run high, so it's usually a bad idea to make adult children the trustee over their parents and their siblings. Corporate trustees, Bank of America, Wells Fargo, Mechanics Bank, they all have trust departments that are staffed with trust officers who manage assets and administer trusts. Now, trust officers come and go, but the trust department will always be there. So that gives corporate trustees perpetual life. And a lot of people like that. They like knowing that they never have to worry about replacing their trustee. The downside is when Wells Fargo, for example, takes over as trustee, they're going to move all of your money from all your different investment advisors into Wells Fargo to manage. When they do that, they've now created a conflict of interest between doing what's best for Wells Fargo, doing what's best for you and your family. Also, trust officers typically have around 100 to 120 files to manage, and the trust department can be located in another city or another state. So the level of care, the level of service that you get may not be quite what you expect. The third option are private fiduciaries. Fiduciaries are people that are licensed by the state of California to act as trustees, agents, and conservators. It also includes attorneys and CPAs, because by nature of our license, we're allowed to be fiduciaries. Because we're not financial institutions, we can never move your money in-house to manage. Instead, we work with your existing advisors to manage your funds, to take care of you, and to take care of your loved ones. So, to wrap everything up, if you become incapacitated or after you die, the documents you have in place are going to determine whether the legacy you leave is a blessing or a disaster. I'm Barry Finkelstein. I'll be here after the presentation, and I'm happy to answer anybody's questions. Amit, back to you.
Thank you, Barry. That was very informative. I appreciate it. If anyone has any estate planning questions, please type them into the Q&A box. I do appreciate all the questions coming in. Stuart, I see your questions, and I'm saving them for John's section because they pertain to the DST. So we'll get to those questions once John does his presentation. So I'm going to go ahead and give John the host controls, and he will share his slides with us.
Excellent.
Any questions regarding Barry's presentation? Feel free to type them in. We'll also be around to answer them at the end as well.
Excellent. Amit, do you see my screen?
We see, yes, we see your screen.
Excellent. Well, Barry, excellent job. Obviously, in my line of business, we work with a lot of estate planning attorneys, and you made this very enjoyable. I was not offended. I enjoyed making light of the situation, and it's such a dense, complicated, important subject. I think injecting a little bit of humor was something I really did enjoy. So thank you for that, Barry. My role here is to talk about the 1031 process. So we're going to talk about the 1031 process, what that looks and feels like, whether you're doing an exchange with a Delaware statutory trust or you're doing private real estate on your own. And then we're going to talk about the passive option in being able to fulfill your 1031 obligations, but doing it in a passive manner. Just as Barry talked about, at a certain point in your life, you don't want to be as hands-on. And we have found that the Delaware Statutory Trust really helps with that. So when we look at Internal Revenue Code 1031 exchange, it talks about replacing debt and equity or in an exchange. And if you're able to replace at equal or greater values the debt and equity, you're able to kind of push those taxes out. And the term is very morbid, but it's swap until you drop. And there's many, many investors that have done hundreds of real estate transactions over sometimes 40 or 50 years. And if you follow the rules, you're gonna successfully defer all of those taxes, and then upon death, your heirs are going to get a stepped up basis. So very, very high level, important tax planning where you can have one of the most impressive assets out there, real estate, over time, and you're able to grow that in a potentially tax-free manner by deferring and deferring. So we're going to talk about the term like kind, and there's always some confusion. The way I like to simplify this is a property of any nature or character, regardless of different grades, property types. And what we mean by that is if you have an investment property, whether that's raw land, whether that's a duplex, farmland, industrial, you name it, any type of real estate that you hold for investment purposes, you're able to do an exchange into another type of investment property. But it's important to know, if you're exchanging a duplex, you don't need to find another duplex. You can find a triple net, you can find a larger apartment, and we'll talk about some of those areas over time. So interests that qualify and interests that don't qualify. Interests that qualify are TICs, tenants in common, long-term leases, water rights, mineral rights, oil and gas, rental homes, and business properties, all qualify. What don't qualify is land under development for reuse. If you're flipping a house, we all love Flip That House on HGTV, but this is not something that's going to qualify for an exchange. You can't flip your REITs that you own. And importantly, you can't use the 1031 rules for your own personal residence. When trying to do an exchange, I mentioned this, you need to have equal or greater equity and debt. And so sometimes this is confusing, and you have to know your property. You have to know how much debt you have on that property. And it's not the end of the world if you find a great asset, but it's of lower equity or a lower debt than you're in. It just means that you are going to have a taxable event. And so when we say replacing full equity and full debt or greater, what we're trying to do is fully defer all of those taxes. Again, my father taught me at a young age, paying taxes is not the worst thing. It means you made money, but we try to help maximize that. So the way to maximize the 1031 rules is by replacing both debt and equity on a transaction. So quick little example, column A here is a successful exchange. Client sold $1 million asset. They had 50% leverage, 50% equity, 50% debt, and they found a replacement property. That costs $500,000 of equity, so we're at equal or greater value there, and you see the debt was increased by roughly $270,000. So in this scenario, they've successfully deferred all of the taxes. Let's look at a situation where a client is going to have some tax liability. Within the real estate industry, the term is boot. So in this scenario, we have $1 million duplex. It's that same 50% leverage, so you're at $500,000 of both debt and equity. But on the replacement property, you decided to be perhaps a little bit more conservative, and you rolled that $500,000 of equity over, but the purchase price wasn't above $1 million, and the purchase price was $830,000. And so in this scenario, you did not replace the $500,000 of debt that you needed to successfully defer all of the taxes. So in this scenario, you're going to be responsible for paying taxes on that, in this scenario, $166,000. Two really important guidelines when you're preparing for a 1031 exchange. The exchange structuring begins before the asset is sold. A good real estate agent, most real estate agents are going to ask, are these proceeds going to be a 1031 exchange? And if so, they insert language into the closing contract. And what that contract and what that closing language is going to say is that the money is going to be sent to someone called a qualified intermediary. And the reason it's sent to a qualified intermediary is that if you take constructive receipt of those proceeds, and what that means is you sell a home, and in the transaction, when it's finalized, they send those proceeds to your bank account. That means it's a taxable event already. And I know I get calls, not weekly, but a couple of times a month saying, you know, John, I heard you speak at this event, and, you know, we want to do a 1031 exchange, and we're interested in a Delaware statutory trust. And I say, where are you with the process? And they're like, you know, we just received the money. And unfortunately, I'm the one that has to break the news to them that they owe taxes on that. And so by not receiving constructive receipt, by having that money go to a qualified intermediary, they're going to hold that money in your name. Think of it as a trust company, or almost like a bank. You want to research them. You want to make sure they're a good company, and they're going to hold that money for you, so it's not a taxable event. And then when you're ready to proceed and find a replacement property, and so I've kind of spoken about this, but to really encapsulate it in one slide, the role is very important that a qualified intermediary plays. They're going to incorporate that language. They're going to complete the escrow and trust account setup. They're going to manage the 45 days that you have from once that money goes to the qualified intermediary. You have 45 days to identify replacement assets, and then 180 days to finalize that transaction. And we'll spend a little bit more time on that in a few upcoming slides. They're going to initiate that final transfer of 1031 proceeds. And what I like to say, in addition, you know, to your advisor like Ahmet and Barry and your tax attorney, maybe your CPA, this is part of your team. They work for you, and it's important that when you're doing a transaction like that, like this, you have very, very competent important industry-leading professionals to help you. For those of you who are more visual learners, I'll start at the relinquished property. That cash goes to the qualified intermediary for you. And then once you find that replacement property, you're going to dictate terms, and that qualified intermediary is going to fund that property for you. We talked about the timelines. This is another important process, and it's important to know why Cantor Fitzgerald with the Delaware Statutory Trust can help. 45 days seems like a lot of time from when you sell an asset to find replacement properties, but it moves very, very quickly. So if by day 45 you haven't found an asset to identify or multiple assets to identify, you're going to be looking at paying taxes. So the passive way of fulfilling the 1031 obligations, where a company like Cantor Fitzgerald already has an asset, already knows the cash flow, already has a loan in place, it's a passive way to complete this exchange. And you can call us on day 44 or day 43, and we're going to be able to help you with that identification process. And then after that, you have another 135 days from the 45th day to actually close on that transaction. A lot of Delaware statutory trust investors want to have this 180-day process condensed down to about 7 days so they can start receiving cash flow on the asset. We talked that the qualified intermediary is going to help you identify replacement properties, and there's paperwork that's involved. There's 3 ways to identify replacement property. I'm going to spend the majority of the time on option 1 and 2 because it's really about 99% of the exchanges. Option 1 is very simple. You're going to list 3 properties by address, any 3 properties, and as long as you close on one of them, you fulfilled those obligations. Very clean, very simple. The majority of exchanges happen this way. Option 2 is a little rarer, but still comes into play, and it's called the 200% rule. Any number of properties, so in the first option you could only list 3, this is any number of properties as long as the fair market value of the replacement property does not exceed 200% or double of the exchange property that you sold. And so again, I know that sounds complicated. That's why you really need to have a great team to help you navigate this. So let's now talk about the benefits of the 1031 exchange. We think it's potentially the single most important tax strategy for preserving and growing the value of real estate. And the reason we think that is depending on how long you've owned a property. And in the Bay Area, we work with a lot of clients that have owned property for 30 or 40 years. And if they were going to sell and pay taxes, it would take a big chunk of those proceeds out. So by using the 1031 exchange, you can basically have all of that equity, and Ahmet talked about that trapped equity. You can have all that equity working for you as opposed to sending that money to Sacramento or Washington, D.C., where it's working for the federal government. So one of the best ways to continue to make money is not taking this huge chunk of taxes out. Taxes have changed. Obviously, we're talking about 2017 taxes here, which is a little outdated. But depending on what state you live in, taxes are going to take a big component of your return. A lot of people like to reposition real estate. We're in a COVID situation right now. And so I think this is very timely, as we see a lot of people are saying, I don't want to pay taxes, but I don't want to be a landlord. Ahmet did a great job talking about the changes and who has the power dynamic. Is it the landlord or the tenant? And that's a more complicated conversation that I want to go into. But our feeling at Cantor is that, especially in California, tenants are going to continue to have an upper hand in the foreseeable future. So you can reposition your real estate. You can go from one property to several. You can change your type of real estate. You can change your geographic exposure. You can reduce management responsibilities if you'd like. And in some cases, you're going to be able to increase your income by buying a new asset and putting more of that trapped equity to work for you. So now let's talk about the Delaware Statutory Trust. This is IRS ruling 2004 of the Delaware Statutory Trust. And to make this really simple, a company like Cantor Fitzgerald is going to go out and buy a large asset, whether that's a $100 million apartment building, an Amazon fulfillment center. We're going to buy that asset and we're going to put it in a Delaware statutory trust, which is just a trust that's set up in the state of Delaware. The asset is put in the trust. So investors in the DST are not direct owners of real estate, but instead they own an undivided interest in the trust. IRS Code 2004-86 is the reason we're able to have this webinar now. The Delaware Statutory Trust fulfills all of the 1031 requirements. If you remember a couple of slides ago, we talked about you can't, do REITs, but also the disadvantages. My family's been here for a long period of time. I'm going to be here working with clients for a long period of time. And when you have a longer time horizon and spread that around to multiple assets, non-recourse debt is important. CPAs really like it because you're going to get a new depreciation schedule and you're not personally responsible for that debt. So those are the advantages of the Delaware Statutory Trust. The downside of them, or something that people need to be comfortable with, is DSTs are illiquid. This is not something that's sold on a stock. There's no secondary market. And so when we work with clients, Ahmet and I, we want to make sure that they feel comfortable holding this asset for 5 to 7 years. Because the investors do not have control. You're giving up that control of property management and when to sell the asset, and you're entrusting an 80-plus year company, Cantor Fitzgerald, who has unbelievable real estate knowledge, by owning Newmark. Newmark is the 3rd or 4th largest real estate company in the United States. For people in Silicon Valley, they're probably aware or have seen the signs for Cornish and Carey. That is now under the Newmark family. So investors don't have control. The decision to buy or sell is made in a fiduciary manner by the sponsor. Selfishly, Cantor Fitzgerald and other Delaware statutory trust companies want to do right by you. So the next transaction, you're going to work with a Delaware statutory trust. There's no requirement. Some people say, you know what, COVID, this is a challenging time for real estate. I'm going to do a Delaware statutory trust for the next 5 to 7 years. When I get liquidity from that, then perhaps I'll go buy another apartment in the Bay Area. But in this time period, I don't want to be a landlord, and I don't want to be working with tenants. Just to kind of close up, and then we can go to the Q&A. this is a very, very interesting environment right now. We are managing through COVID. We are managing through a shelter-in-place kind of environment that's slowly getting back to normal. And I think a lot of people thought, just on valuations, that there's a famous quote by Sir John Templeton, buy when there's blood in the street. And a lot of the transaction volume in Q2, fell off. In the multifamily space, large apartment buildings, the transaction volume was off 70%. If you were a seller of real estate and your asset has performed, you think there should be a premium paid. Whereas if you're a buyer, you think we're in a pandemic and you want a 10 or a 15% discount. And so it's been very interesting with all this situation that we're in now. We see this all the time. Death is something that happens, and we see kind of two things. That standard, there's 3 kids, we're going to do a third, and everyone's going to get their prorated shares. We do that all the time. The other thing that we have seen is that there's kind of that horse trading between the heirs. I want the vintage Porsche, and we're going to make all the math work at the end, and maybe you take all of the DST interest. So it's very easy for estate planning. We're going to follow that will. There's a form to complete, but you're just going to let us know as you go through that process. Are we splitting this up 50-50? Is it a third, or is it all going to one client? The other thing that I will just throw in as an anecdote for the Bay Area, because if the deceased passes away in 3 years, there's another potentially 3 or 4 years left on the program and cash flow. And I always thought that as a negative, and more in the Bay Area, I'm hearing from clients saying, you know what, I don't want to give the kids all the money. The fact that they're going to get a monthly allowance, so to speak, and they're going to hold that principal back 3 or 4 years, John, I think that's very exciting, and my kids are going to inherit enough, and we don't want to give them all access to that money because of the potential downside.
Great. Thanks, guys. Another question that came in, this one's, I believe, for Barry. Are you suggesting to put each LLC in a trust? How about complications of tax by the Franchise Tax Board? What is your suggestion? Also, if it's a triple net property, do you recommend an LLC?
So each LLC has its own tax exposure. There's an $800 a year filing fee. So, are we talking about a 30-unit apartment building versus 2 single-family residents? So before we jump into an LLC, we're going to do an analysis and look at what makes the most sense. What's the best and most cost-effective way of protecting that asset? But if we do have an LLC, then yes, we want to put the LLC in the trust so that when the trust maker becomes incapacitated and dies, the successor trustees have access to that asset to manage it, to liquidate it, to distribute it.
Great, thank you, Barry. Scott asks, in a DST, do you also receive a depreciation schedule based on your rolled-in basis? Are the DSTs that are single asset specific but act more like a mutual fund that are both more diversified as well as more qualified? Thanks for the question, Scott. I'm going to jump ahead a few slides. So the answer to your first question is yes, you will receive a new depreciation schedule based on what you rolled over from your relinquished property. And as of in 2019, there are about $3.5 billion raised in the space, and which is a 40% year-on-year growth from the year before. Currently there are about 38 sponsors that are actively in the DST space, and they come in all all types of flavors, with multifamily making the majority of the DST space. But you have DST programs that are single asset, that is one building. You have a portfolio of buildings, whether it's a portfolio of apartment buildings, portfolio of self-storage, or a portfolio of single tenant net lease properties. There are many flavors out there, and depending on what you're looking for, there's chances are you'll be able to find something that fits your needs and requirement. I don't know, John, if there's anything else you want to add on to that.
Yeah, the question also, a portion of it talked about multiple assets versus one asset. We believe the best way to diversify is to go into multiple Delaware statutory trusts with a single asset. And the reason I say that, and other firms may have a different view, but if you have 2 or 3 assets in the Delaware statutory trust, I get where your mind went, oh, I'm diversified. The issue is if you put $100,000 into that trust and there's 3 assets and those assets aren't sold at the same time, you're going to get that money back piecemeal. And depending on the size of the account, to get a $30,000 return of principal, it then might pose replacement issues at that size. So no one is saying diversification is not the best way to do it, but we prefer to diversify in multiple single asset DSTs. It makes the exit process and potential reinvestment, we feel a little bit more attractive.
Great, thanks for the question. Had a question for Bar Klein. What is the best resource for identifying DSTs? Bar, happy to speak with you. We specialize in 1031 exchanges and helping investors place equity into DSTs. Out of the 38 sponsors that we saw on the previous slide, we work with, maybe the top 15. It's very important to work with an advisor that understands real estate in addition to the DSTs. So happy to sit down with you, talk about the ins and outs of the DST and what to look for when selecting DSTs down the road. Thank you for the question. Any other questions out there? So next steps, if you need any help regarding property value assessments to compare existing income versus potential income with a 1031 exchange, we can provide that. We can help with the sale and reinvestment of your property, which would into DSTs, triple net, or out-of-state properties. If you need referrals to any tax professionals specializing in real estate or any qualified intermediaries, more than happy to provide those referrals to you. We'll stick around for a couple of minutes to answer any of your questions. I want to thank you all for coming and for joining us today on an informative webinar. Definitely appreciate all the questions that came in. Also, if anyone's interested in an ebook, this ebook covers some of the strategies that we talked about today on today's webinar, including 1031 exchanges, DSTs, single tenant net lease properties, as well as the 1031 exchange. Happy to send that to anyone that may be interested. So we'll leave it to Q&A. I want to thank Barry and John for joining, and look forward to connecting with people in the near future. A few questions came in. Another one from Stuart. On self-storage DSTs, the depreciation is 39.5 years on the improvements and the land has greater value, right? So, correct. On commercial properties, the depreciation schedule is based on 39.5 years, or residential is 27.5. And typically in the areas that these DSTs are located, the structure, the improvements has more, takes a greater portion of the overall value. Typically around 80%-ish, but it depends on state by state. I don't know, John, if you want to add on to that.
No, I think you handled that. I try to shy away from the very detailed tax questions in a group setting.
Well, obviously I have to preface, talk to your CPA regarding your specific situation. Scott asks, are there any DSTs that act more like mutual funds that can be sold transfer ahead of the asset exit strategy? Yes and no. So there are some sponsors out there that structure their DSTs with the goal of doing a 721 UPREIT. And what that means is you would be exchanging into a Delaware statutory trust, and either at some point during the holding period or at the disposition phase of the property, the sponsor will opt to do a 721 UPREIT, which means they take the shares that you have in the DST and turn them into operating shares into a REIT, a real estate investment trust. And that allows you to access a larger pool of assets that are already existing in the trust, as well as be able to potentially sell some of the shares you have, but obviously there will be tax events. So in a sense, when you do the 721 UPREIT, you will be joining a pool of existing rental properties, which may provide some diversification, but also the REIT, the UPREIT structure allows you to sell some of your shares, and typically the sponsor of the UPREIT is the one that's purchasing it at the market rate. But there are no guarantees that they'll purchase it, but that is more of the mutual fund type of structure I believe you're alluding to. I don't want to say once you do the 721 UPREIT, you do lose the benefits of doing a subsequent 1031 exchange. So this is typically for people who are done with the 1031 exchange, done with management, or they may believe that the 1031 exchange will disappear in several years. So the 721 UPREIT option is something to consider. Awesome. Great. Well, I want to thank everyone. I see some more stuff coming in the chat. Chiyuan, the ebook, I am more than happy. I will follow up with an email, or you can send me an email and I will send you the copy of the ebook. Dimitri asks, can you just send the ebook slides and recording that everyone has signed up? I will send an email and respond with what you want, which documents you want, and more than happy to send that to you, Dimitri. Another one accused. Another one from Stuart. Appreciate your question, Stuart. On DSTs, if a sponsor goes bankrupt, can the loan be called? John, this one's for you.
The loans in the Delaware statutory trust business, you're not allowed to refinance. So I am not sure if a sponsor goes bankrupt, what would happen there. I think you want to look at the financials and not be in that situation. And I think that's where the higher quality Delaware statutory trusts really stand out.
So, I'd also like to add, the trust is a separate entity from the sponsor. The sponsor and even if the sponsor goes bankrupt, the trust is operating on its own. Correct me if I'm wrong, John, but the trust will end up having to find another sponsor to come in and manage that specific property, correct?
Also, there could be a springing LLC situation. So happy to dig into that a little bit more deeper, but not a scenario you want to be having.
Great. We have a question from the Silvera family. As far as the new rental laws of 2020, I have seen similar ID rulings. I'm not sure what ID rulings stand for, if you can elaborate, for single family rentals and duplex. Is that true? I'm not quite sure what ID rulings stands for, but on the ballot for Prop 21 would essentially get rid of the Costa-Hawkins protections for single-family homes, which would make them eligible in some jurisdictions to fall under rent control. If you want to elaborate on what ID rulings, I could be happy to answer that. All right, everyone, I want to thank you. It is 20 minutes past the hour. We're way beyond what the allocated time. Just want to thank everyone for coming. Thank John, thank Barry, and look forward to connecting with everyone soon.
Thanks, Amit. Thanks, everyone.
Thanks. Scott, I will answer your question offline in an email.